guys are able to hear.
Yeah, we can hear you.
Yeah, sorry about that. My sound took a minute to connect there.
That's awesome. Okay, welcome everybody. Thank you so much for joining us today. My name is Alex. I am the member support in SA for restaurant and catering. I am joined by the lovely Julia Robinson and Mary Caposo here in SA for membership support. I'd like to thank you all so much for joining us today. We're so fortunate that we're able to run these online events and be accessible to everyone around the state. I'd like to introduce you all to our panelists that we have here today. We have Lungaka from the Working Women's Centre, and Lungaka will be introducing what the Working Women's Centre do for us here in SA, and also share some of their client experiences relevant to the hospitality industry. We have Brendon, who is our Restaurant and Catering Association Senior Advisor of Industrial Relations. And he's supported by Sarah, who's at the Wallmans Lawyers. Sarah is part of the Employment Safety and Workers' Compensation team at Wallmans Lawyers. Brendon, supported by Sarah, will be presenting on the Restaurant Industry Award changes. Many of you have clicked through our email about the Restaurant Industry Award changes, so you may have already have access to that complimentary explainer document. This is certainly an opportunity for you to ask any questions you may have or to get further clarification on the changes to the industry award. And we really are the best placed to support you in that, as Restaurant and Catering Association did design and write those changes. Lastly, we'll finish up with the lovely Greg Hobby, who is the chair of the council in SA. I'd like you to certainly interact with us and ask questions and comment and use the chat feature down there to engage with us through this webinar. So I'd like to hand over to Lungaka to talk to us about the Working Women's Centre.
Thank you for that, Alex. I'll just see if I am able to share my screen. Can I confirm that you guys can see my screen?
Yes, we can. Thank you.
Yes, thanks.
All right, so as Alex said, I am one of the industrial officers here at the Working Women's Centre. And before we go any further, I just want to acknowledge that the land that, at least that I am on, is the traditional land of the Kaurna people, and that we respect their spiritual relationship to their country. We also acknowledge that the Kaurna people are the custodians of the Adelaide region, and that their cultural heritage and beliefs are still important to the living Kaurna people today. So just moving on to a little bit about what the Working Women's Centre does. The Working Women's Centre started in 1979 as a little caravan that would go around to workplaces and give some people industrial advice. So it's grown a lot since then, and now we have 4 main areas of what we do. And the first and the main part of what we do, we provide free advice and representation to women and vulnerable workers. And that's the bulk of what we do, and that's the biggest part of my role. We also do research and lobbying, which we have an advocacy team that takes care of that, and just research and lobbying around workplace issues. One of the lobbying in the areas that we're focusing on at the moment is insecure work, which I think is quite relevant to the hospitality industry. I'll be happy to share the report once it's released. We also provide training for organizations, and like one of these, we do like small business seminars and so forth based on high risk industries that we've identified from our data. And we also do fee for service training on consultation on things like sexual harassment, how to handle bullying complaints, and so forth. So that's a bit of an overview of the kinds of things that we do at the Working Women's Centre. Now, in terms of just looking at the inquiries that mainly come through to us, the healthcare and social assistance industry has the highest rate, and hospitality comes second to that. So we've identified hospitality as a high-risk industry. And when we've looked at, I guess, trying to understand why hospitality is such a high-risk industry, done a little bit of research into the Australian HR Institute. They look a little bit as to why, like, the issues that are at play as to the reason as to why people leave the workplace. And I just have some of the reasons that they've identified, including lack of career progression, better pay, and so forth. They've also provided, solutions to that in providing some training and development opportunities, flexible working arrangements, and so forth. So I do find that a lot of these will overlap much with what I will be sharing today, but we'll see how we go. I'm also happy to share that report as well. I do think it gives some pretty good insight about just the high risk turnover, because even though the turnover rate in Australia is about 8%, the rate in hospitality is actually like 17%. So it's quite significant and relevant to the hospitality industry. Now, moving on to the types of matters that we see, the types of inquiries that we've seen. Dismissal and redundancies are probably the highest ones, followed on forth by the employment conditions, underpayment of wages, and I've kind of used the data that we have based on matter type to guide the main areas that I'll be focusing on today. Sorry, I didn't put my phone on mute. There we go. So, the first thing that I'll be looking at is fair investigation and disciplinary processes. I'll try to speed through and get through all of these. Fair investigation and disciplinary processes, which often lead to dismissal and redundancy processes, employment conditions and employee protections or general protections, some issues that are at play with underpayment of wages and workplace bullying. Now, just being conscious of time, we may not be able to get through all of those, but we'll see how we go and how we track on time. And Alex, feel free to send me a message and let me know if you have some concerns.
If anyone in the webinar has a particular question on any of those points that Lungaka has just mentioned, if you'd like to pop a question in the chat, or if there's something in particular that you want answered, maybe just put a little note there in the chat for us to just draw a bit more attention to it. Sorry, Becca.
Yeah. And I have chosen to do a broader overview of everything. So a lot of the information doesn't go in as much depth. So if you do have further questions about it, feel free to, let me or one of the other panelists know. So I have a little story of Jane, who's having trouble getting along with another waitress, and, get into arguments over who's supposed to do what in service, and the other waitress complains, and after Jane shifts, she's given a warning and nothing's done to the other waitress. Classic thing that we see coming in all the time here at the Working Women's Centre. And I just want to use that as an, little case study to analyze, I guess, some of the fairer or, best practice in terms of handling a disciplinary and investigation process. And the first part of that is having an investigation. Oftentimes we find that action is taken without an investigation actually being held. And I think an investigation needs to be independent. And some of the times you'll see that there are some structural issues that are at play, and it can actually easily be solved by setting up some training, setting up clearer structure of who's supposed to do what, and some conflict can be avoided that way. And if it reaches a stage where an allegation needs to be made, having an allegation letter that is specific enough so that the employee can identify what it is about their behavior or their conduct that actually is, an area of concern. So we often see allegation letters that are really broad and general, that don't have dates and times, and often leave the employee just a little bit in the dark as to what exactly happened. And the next part of that would be, having a meeting as part of that investigation process. And it's important that, the meeting is held during work hours, and that you offer the employee a support person, and you give them a genuine chance to tell their side of the story, and that a decision isn't made before they even tell their side of the story, and that's what we often see. So in terms of the outcomes of the investigations, there could be training, performance improvement plans, warnings, and dismissals can sometimes be, appropriate. And just another quick word on performance improvement plans. They also need to be there needs to be a clear pathway to improvement with measurable outcomes. Oftentimes we see performance management plans that don't have measurable outcomes or that are unreasonable with things that the employee is never going to be able to reach, or some vague terms as to improve your KPIs, but doesn't set the actual number. The more specific, the better. And it needs to provide that employee with support along the way and provide regular checkups so that the employee can track how they're going with their opportunity to respond and to improve their performance. And sometimes dismissal is the best option, and that is okay. Oftentimes people think that we think people should never be dismissed, but that's not true. It's just a matter of ensuring that the process of dismissing someone is reasonable and is fair. And again, we have Jacinta, who has been working for 3 years. She is a casual and she's late a couple of times and is fired for it. Maybe that may be reasonable, that may not be, but in terms of looking what the Fair Work Act says about dismissals, it requires for a dismissal to be unfair, there needs to be 4 elements. And the first of that is that there actually be a dismissal. And dismissals don't just include actually telling someone that you fired, it goes beyond that to include a demotion. So if you are performing a role that has 70K a year and certain roles, and then as a result of a decision by the employer, they are given a lower position that attracts less pay and so forth, that can also be perceived and construed as a dismissal. And also just reducing someone's shifts by at least 25%. There's a few different ways that where employers won't believe that they have dismissed someone, but they'll actually be a dismissal. And it needs to be harsh, unjust, and unreasonable. And there's a few factors that come into play in that, in terms of there being an actual valid reason for dismissal, offering that person a support person in a meeting, that person being given a warning of some kind, that their conduct or performance issues could lead to dismissal. And what the Fair Work Act does, it also takes into account the size of the business and their abilities to provide HR resources and so forth. Another category is non-genuine redundancies, and small businesses are actually exempt from having to make redundancy payouts. However, they do still need to follow their due process, and the redundancies still need to be genuine. So if the role is still required, it will be considered to be a non-genuine redundancy. And if there are redeployment opportunities within that organization that the worker could do and could simply have maybe 1 or 2 days training to go into, that will also be considered to be an ungenuine redundancy, because there's a role within the organization that that employee could still perform. So for small businesses, I would really recommend just following the Small Business Fair Dismissal Code, as it provides lots of guidance, and it basically guides you through the factors as to what makes a dismissal fair and unfair. And I think as a small business owner, that if you just follow that, it will be a safe route to making sure that you avoid any unfair dismissal claims. And in saying that, there's lots of processes that need to be followed. Summary dismissals are an option where the conduct is serious enough to warrant termination immediately. And that involves things like theft, fraud, and actual or threatened violence, and so on.
Lungaka, we just have a question from Sonia asking, if you demote someone's position but continue to pay at the original rate, is that considered dismissal?
So there's a few factors at play. So I would say that the rate is one thing, but it actually involves both, not just the rate, but the role as well. So if it's a demotion in terms of the roles that they perform, or someone was a supervisor and now they're expected to work in a normal role, that can be construed as a dismissal. So it's not a black and white. It is something that's weighed up a bit, but definitely even outside of the pay, the role itself is a significant consideration. Dismissal, regular, systematic. Okay, and I just want to point out regular and systematic casuals, and this is something that comes up quite a lot, that we see where employers and often employees themselves assume that casual employees can be dismissed and that they don't have access to unfair dismissal remedies. And when casual employees are regular and systematic, they are actually, they have the same rights to an unfair dismissal as permanent part-time or full-time employees. And for an employee to be able to access the unfair dismissal remedy in the context of a small business, they need to have been there for at least 12 months and to actually have regular and systematic shifts rather than the sparing one shift every once in a while. So I think that's an important fact to consider. So these are just some of the factors that are at play when deciding whether or not a dismissal was fair or whether it was not fair. And I would really recommend that if you've decided that dismissal is the best route to go, to hop onto Section 387 of the Fair Work Act and see if these factors are in your favor, and if they're not, just taking the appropriate measures to ensure that they are. And moving on now to employment conditions and employee protections, or general protections as we call them. So we have Jessica, who's a part-time waitress who works 24 hours a week. She becomes unwell, takes 2 weeks of personal leave, and while she's away, she's diagnosed with a chronic illness and comes back and discloses her illness to her employer. And the employer tells her that she's cost the business money because they've had to hire someone while she's gone. And since she's been given a diagnosis, to reduce the risk to the business, they've decided to cut her hours to 12 hours a week. Again, this is an unfortunate story that we see quite often. And going on from that, there are certain rights that employees have that are protected by the Fair Work Act. And there are many of them, but I'm just going to focus on a few. And that includes exercising a workplace right. So if an employee is exercising a workplace right, like calling in sick, taking sick leave, that's a right that employees have, not only under the national employment standards, but also under the award itself. And an employer is not permitted to take adverse action against them. And what adverse action means is whether it's dismissal, whether it's refusal to engage or employ, and whether it's injury to employment, reducing hours and so forth, and changing the position in any way to the employee's prejudice, or treating them unfairly or less than in any way, discriminating against them. So there are certain grounds that are protected, and that includes discrimination based on sex, race, and disability. And it's important to clarify that with a disability, it's not just actual disability, but it's perceived disability as well. So if you've decided that an employee is sick, you can't just, if you think that they have a health condition that will make them unfit for work. And I think the risk, or the thing that happens quite often, is that the employer will decide that their employee is not fit for work rather than waiting for a medical clearance of some kind. And that's where we'll oftentimes run into trouble. So want to clarify again that this doesn't just apply to existing employees, but it also applies to prospective employees. So if the only reason why someone is not hired is because they have a sickness of some kind or a perceived illness or based on their race and so forth, that's also protected by the Fair Work Act and not permitted. I feel like I've done a quick scan over what general protections are. They definitely go much deeper than that, but I think that gives some idea as well. So if an employee needs to take some time off for, some health concerns, again, oftentimes they will come back and get told that, their jobs just isn't there anymore, and that will lead to a general protections claim. And also industrial activities, which I won't go into too much because we are not a union.
Lungaka, are you happy to stay on a little bit longer, just in case anybody has any further questions on?
Yeah, sure.
Discussed?
Yeah, and I would also be happy to share my email address if some other questions pop up at a later stage.
Thank you.
So moving on to the underpayment of wages, what we often see is that, I would say that the highest risk factor for this is the absence of an employment contract, where their employer and their employee are kind of going blind as to what their employment conditions are. And I would say that people not being paid their casual loading, if they're casual employees, not being paid weekend and penalty rates and so forth, superannuation, and incorrect or the lack of classification completely. Probably these are the things that lead to an underpayment claim. And just moving on to the risks that come with that, it's not just the underpayment claim itself, it's also the pecuniary penalties that can come with that. So oftentimes, even the employee themselves will be surprised to see that there are certain provisions in the Fair Work Act and within the award that are deemed as important enough that there will be a penalty that's imposed in addition to the underpayment that we often advocate as paid to the employee. And I guess on a broader level, that these kinds of things not being paid enough, if you remember to the table that I shared earlier, that one of the main reasons why people leave is to get higher pay elsewhere. So it does lead to employees not being too happy with their work. And I'm not going to go too much into that because I believe Brendon's going to cover the details as to what the restaurant award says. So another common issue that we come across is workplace bullying and harassment. And I'm going to read out this story because I think it really just clarifies, I guess, some of the detail and the nuance between everything that goes on. So one is an apprentice chef who's recently started. She's the only woman who's the chef. And when she makes mistakes, there's small little comments made like, oh, you had a girl try, or they often make jokes about her appearance. And when she complains, she's told that it's just banter and that she needs to stop being a princess and so forth. And I think a lot of the time banter can be dangerous territory when there isn't a clear line drawn between what's acceptable and what's not acceptable. And the Fair Work Act does define what bullying is, and it includes repeated and unreasonable behavior directed towards an individual or a group. It threatens or intimidates, humiliates a person, and it creates a risk to their health and safety. And some common examples that are not often perceived to be bullying or harassment, but is belittling or humiliating, using offensive language, undermining someone's work performance, displaying offensive material, unreasonable refusal of requests for leave or training, and being excluded or singled out, and also setting unrealistic expectations that the employee is never going to meet. And I guess in looking at what the risks of that is, so we always encourage employees to follow the internal processes. When it comes to workplace bullying, that's the first point of call, not only from our perspective, but the Fair Work Act actually requires that. So it is only when their employer has failed to take corrective action after a bullying complaint has been made that an employee can even access the Fair Work Commission in trying to, ask for a stop bullying order. And another thing in that it contributes to a toxic work culture where really you are just waiting for workers' compensation to happen at any point because people are constantly being bullied. It's being classified as banter and so forth. So oftentimes bullying is perceived as not that serious, but when it is persistent, it can actually cause some harm to the employee, which can lead to workers' compensation claims, which we see often as well. So I would say that the crux of it is really to create a healthy workplace culture where employees feel valued and encouraging sick leave where employees are actually sick. I think one of the biggest red flags that we see is employees who are terrified and scared of calling in sick because they feel that maybe their shifts will be taken or, that there's going to be some kind of adverse action taken against them. I think even as an employer, if your employees are terrified of taking sick leave, that should be a red flag to you that some work needs to be done in terms of building a workplace culture that is healthy. And same goes to like offering flexible work arrangements when they are necessary and offering casual conversions and secure work. Now, again, small businesses have less obligations to provide casual conversions. But in saying that, it does go a long way to providing secure work. With hospitality being such a high turnover industry, it would probably go a long way in making a difference if employees were actually offered part-time and full-time positions rather than always being offered casual, well, not always, but more often than not being offered casual positions. I'm just going to read a question quickly.
Lungaka, we might leave that question for Sarah at the end and use this as an opportunity to continue what you've got in front of you about the contracts and the awards that we have at the moment. And then might potentially throw back to you again at the end as well for any of that. If you don't mind, I'm more than happy to go on about the awards.
Yeah, that's
Excellent.
great. And I do think that's the benefit of having both sides, because I mainly focus and represent employees. And I think your perspective is going to be interesting on most questions as well.
100%, 100%. All right, well, thank you for that discussion, and hello to everyone from South Australia. I'm Brendon from the Industrial Relations team here at RCA. It's good to see some familiar names from SA. I know Alex, Mary and Julia have been working hard, and they escalate issues that you raise to them, to me as a final resort if you have any IR problems. So it's good to be able to see some of those names here today. I'm of course joined by Sarah Lithgow from Wallmans Lawyers, who is the Adelaide-based law firm. And so if you've got any additional questions from what we're about to discuss or any other follow-up things, by all means get in touch with them. And so I'm just going to be talking about, as Lungaka mentioned, the restaurant industry award changes that have come into effect from August. And there are essentially three options for employers to opt in and to pick and to choose what is appropriate for you. One of the things that we find in the industry is that, there are concerns and there are systematic things that we would like to see addressed. And that's a big part of these changes. So for everyone who is on, I guess the first thing, of course, is out of these three changes, and the first one I'm about to cover is the new classification structure, is that all three of these are opt-in. So you can pick and choose whether you want to use all three of them, one of them, two of them, or none of them, if that's your business context. And I'll just cover the first one. And if you've got any questions, put them in the chat. And as I mentioned, Sarah from Wallmans Lawyers will speak to them and answer them as well. And so the first one, which is the classification structure, in terms of conceptualizing this. So the current award has the food and beverage attendant, has the kitchen attendant, and it has the cook stream. So you've got those three streams. Now the new system now has this chef stream. And what that is those who are the cooks grade 3, 4, and 5, they are now your chefs 1, 2, and 3 respectively. So you've got it here in front of you. This is on page 5 of the explainer guide, if you also have that in front of you. So it's the current grades 3, 4, and 5, as you see in that middle column. They are now the chefs grade 1, 2, and 3, as you see in the left column. And they're paid at the pay grade, which is currently level 4, 5, and 6. So therefore, there is no change. So currently, cooks grade 3 are being paid at the level 4 rate, and that is the same as the new chefs grade 1. And you can see there, cooks grade 4 are being paid at the level 5 pay grade. And so for the qualified cooks, for those who have a certificate 3 and above, there is no change at all. It is a purely cosmetic change. Now, what does that mean for everyone else? And this is the big change. It means for the unqualified cooks, the cooks grade 1 and 2, they have now been combined and amalgamated with the kitchen attendants 1 and 2 and the food and beverage attendants. So you've got in front of you the first row. So the grade 1 and 2 kitchen attendant, the grade 1 and 2 food and beverage attendant, and the grade 1 cooks. They're being paid at level 2. And they're now the new restaurant/cafe worker stream. And so if you are a current grade 2 kitchen attendant or a current grade 2 food and beverage attendant and a cook grade 1, you're already being paid at a level 2 rate. So there's no change there. Now you could say for those who are a kitchen attendant grade 1 and a food and beverage attendant grade 1, they get a pay bump because they're now being paid at the level 2 rate. And if you look at the next row down, the current cook 2 and the grade 3 kitchen attendant and grade 3 food and beverage attendant, they're currently being paid at the level 3 rate. And they're now the restaurant cafe worker grade 2. And there's no change there. You know, they were getting paid level 3 before. They're still getting paid level 3 now. And the last one, which is the amalgamation of the grade 4 and 5 food and beverage attendant, they're being paid at the level 5 rate. And again, for those who are currently grade 5, there's no change at all. But for those who were grade 4 and now being paid at level 5, there is that pay bump there. So you'll see with these two examples, for all the qualified cooks, they're now part of the chef stream. Everyone else, the unqualified cooks, the kitchen attendant and the food and beverage attendant, they've been amalgamated and merged into this restaurant and cafe worker stream. Now, what is the intent of this? As you will see that no one is worse off under these proposals. Either you're being paid the same amount or you're getting a pay bump, for example, for the grade 1s and the grade 4s. The 2, 3s and 5s are being paid exactly the same. And the benefit for this is in response to the skill shortage that we are seeing in the industry. We are seeing and we are hearing from you, hearing from our members about the skill shortage that we're all facing. And what this allows you to do, therefore, is to cross-train and cross-skill some of your staff. So, for example, your kitchen hand at the back can now go front of house and help out with collecting money, you know, during a busy period, seating patrons, getting orders, running dishes out, or vice versa. Your junior wait staff who's at the front can now go back of house, you know, helping out with very, you know, simple cooking duties, whether it be, you know, chopping the salad or putting the buns in the oven or frying an egg, you know, things you don't need to be a qualified chef for. This cross-skilling and cross-training is the intent of this new classification structure, to allow you, because of the skill shortage, to not get in trouble of any concerns you might have about compliance or misclassification, but to know with assurity and with confidence that you can have some of the junior staff conducting a more diverse range of duties which they might not otherwise have been able to do. So that's a classification stream. Now, as you will see, these are the pay rates. And as I mentioned earlier, these are based off the existing levels. And so they will go up in accordance with the annual wage review as it is going up in the 1st of November with those minimum wage changes. Now, the second proposal is something a little bit different. This is more for our larger members. So you would have heard from the first one with the cross-skilling. That's certainly more targeted to some of our smaller members who won't, or who might not have the economies of scale to have dedicated staff with front of house and back office duty and need a mix. Whereas this one is a little bit different. So this is the exemption rate proposal. So the exemption rate proposal is when you have very senior staff, as you can see in front of you, level 5s and 6s, you're talking your front of house managers, your head chef, that kind of seniority. And the exemption rate is very similar to the annualized salary arrangement, but there's a distinction here where they're being paid at 170% of the award rate. So if you're level 5, you can see here, that's 82,441, or your level 6s, that's 84,651. And so you see this, it's quite a premium, and when we recognize that, we're aware of that fact. And in return of that, you do not need to pay anything, and you can offset things such as allowances, meal allowances, meal break penalty, tools and equipment, uniform. You're offsetting things like penalty rates, weekend rates, public holiday rates. You're offsetting up to 57 hours of overtime. You don't trigger overtime unless they work 57 hours. And that 57 hours is not suggesting you to go up to that 57-hour limit. It is certainly a more concrete limit. But as you would know, it's not best practice, and certainly not good for team morale to go up to that 57 hours. But it means you can, go to, as we would know in the industry, 42 hours or 45 hours is not uncommon. The occasional 50 hours and maybe 55 hours. But it's certainly, you can go up to 57 hours before you start triggering those allowances, and because of that buffer that you have. And so you'd use it because, one, you're paying such a salary anyway. And the big thing is that unlike the annualized salary arrangement, where you have to perform the reconciliation at the end of the year, where, you're going to your accountant or your financial controller and you're cross-checking timesheets and when this chef checks in and out and whether this chef has brought their own knife and deserves a tool and equipment allowance, or this person missed a meal break on this day. You don't need to worry about those compliance measures anymore because of that generous buffer in place. And you have assurance that you will not be in trouble for underpayments or any potential claims of wage theft. So you still have to keep track of things like the rostering and hours of work, but you don't need to perform the annual reconciliation at the end of the year. And so that's why some of your members, especially if you're around that 80,000 mark already anyway, you might consider going to this exemption rate, because in return there are the benefits of compliance and a more simplified way to do business without those concerns of non-compliance. And the last measure that you can choose to opt in if it is so appropriate for you is the substitute allowance. So again, if you have any questions, pop them in the chat below. We can see some of the questions already, and we will have Sarah from Wallmans Lawyers answer those questions as well. And the substitute allowance now. So the third and final one, the substitute allowance. So the substitute allowance is an hourly rate that you pay. It's an hourly allowance. And this can be for casuals, this can be for permanent staff. Doesn't matter if they're on the upper end or the lower end. You're paying this hourly allowance, and in lieu of that, you don't need to pay the ones that you see in front of you. So that's your meal break penalty, your tools and equipment allowance, your meal allowance, special equipment clothing, which is your uniform allowance, split shift or distance work. And so we, and I certainly from the conversation that I've been having with the members, see two main scenarios where this is of the most benefit. One, it's the employer, and this might be you, who is so concerned about underpayments and claims of wage theft. So what you do as a result is you provide meals to your employees every shift. You provide your own knives to your chefs so they don't need to bring their own. You provide uniform, and not only that, you do the laundry for your own staff. And you don't do any split shift. Or if you do, you make sure that no staff is doing 2 shifts per day, even if they want to, because you find it easier to skip all those than to worry about when you're going to trigger each allowance. And so you do it all yourself. And so that's one example, one scenario where we see some of our members finding, hey, it's better for me to just pay this hourly rate instead than for me to, worry about doing the laundry for my staff. Now, the other scenario is the employer who puts in the money and the time and the effort to track, this chef has missed the meal break on this day. This chef brings their own knife, but this chef doesn't. So this chef gets the allowance, but this chef doesn't. We just pay the uniform allowance when it's triggered. And for them, they spend the money to deal with the compliance. And for them, it's easier for them, rather than trying to track who does what, it's to pay the hourly allowance instead, and to know that they are covered by this allowance. So that's the intent. And the last one, of course, so those are the two other main ones. The other ones that we may see are those who are, if you're already paying the above the award rate, or looking to pay the above the award rate because of the skill shortage anyway, you might as well use the substitute allowance to offset some of the other allowances that you have. And if let's say you use an annualized salary arrangement at the moment, what you can do is you can add this hourly rate towards it, do this annualized salary arrangement. And when you do need to perform the reconciliation, you only need to do it for overtime or penalty rates, and you no longer need to do it for allowances, because this is an inbuilt buffer for that. Now, these are the hourly allowances themselves. You will see there's a bit of a U-shaped curve. And the reason for that, just very briefly, is basically the mathematical statistics and modeling found that those who are more likely to use these allowances were your very junior staff, like your level 1. And then as you became more senior, for example, you're more likely to bring your own chef's knives or provide your own chef's knives, like the level 5s and 6s, you're more likely to trigger the tools and equipment allowance. And that's the reason why you see this kind of U-shaped curve. So those are the 3 changes to the Restaurant Industry Award that have already come into effect from August. Employers can opt in to use it whenever they would like, and if it is appropriate for their business. But that in turn summarizes my component of the presentation and what these changes are. And I can see here we've got a question about protection, which I might throw over to Sarah from Wallmans Lawyers again to answer for everyone. Thank you.
Thanks, Brendon. So one of the questions we've got through is about how an employer can best manage basically underperforming employees. So there is a perception that there's a lot of protections for employees, which Lungaka has spoken to in terms of unfair dismissal claims, bullying and harassment claims, potentially workers' comp claims. Sometimes employers, and as advisors to employers, we see this happen quite a lot. There is a bit of a fear of managing employees because of the fear that there might be a claim made against you. Unfortunately, putting off the inevitable and not dealing with problems when they arise can lead to more problems down the track. So our recommendation is, and as an employer, you have a right to performance manage employees who are underperforming. If they're turning up late to work, if they're chatting instead of working when they're at work, you can certainly manage that. And what the best course is to make sure that you follow a fair and reasonable performance management process. So what that involves is putting the employee on notice of the concerns you have about their performance, making sure they're aware of what your concerns actually are, so that the employee is in a position to be able to address those concerns and take steps to fix the problems. If after a process of performance management and that involves, firstly pointing out the issues, but then giving the employee a reasonable opportunity to improve, it can get to the point where if the employee is just not improving, then it is open to an employer to make the decision to dismiss them from employment. One other thing which is important to keep note of is, as an employee, you have a probation period there for a reason. So for small business employers, you've got 12 months, and for larger employers, you have a 6-month period where an employee can't make an unfair dismissal claim. During that period, it's really important to use that probation period to monitor employees' performance. If they're not fitting in, if they're not working out, if they're turning up late all the time within that period, then the risks to an employer to end the employment before the probation period, or the qualifying period as it's referred to under the Fair Work Act, they're very much reduced because you don't have that unfair dismissal claim risk. So yes, as an employer, there are risks in managing an employee, but as long as you undertake it reasonably, you generally have a good defence to any unfair dismissal claim that results. or a workers' comp claim or any general protections claim, because you've got a record there of what your concerns were and what you were doing to fix them. And that's just one other thing that is important. While you are performance managing an employee, make sure to keep records of it. So if you issue a warning, if you have a performance management plan in place, keep a record of it. Ideally, have the employee acknowledge it in writing as well. And then if you do need to defend any dismissal decision, you've got those records to rely on later.
Absolutely. Yeah, thank you, Sarah.
Very happy to answer any other questions anyone has. I think that's the only one that's come through so far.
So I've got another one in terms of compliance. As you probably know, for a lot of our members who are concerned about compliance, and let's say they use the annualized salary arrangement, even with the 25% buffer, and they're trying to, you know, when they perform the reconciliation at the end of the year, that they haven't underpaid the staff if they were paid in accordance with the award. What do you find in terms of the best way for members to perform the reconciliation process, where it is quite an administrative task in terms of gathering all the timesheets and trying to plug those numbers in and make a comparison to what was actually being paid? And how can they, you know, continue to do that better so that, you know, even if it's throughout the year, rather than waiting for the end of the year for the annual reconciliation, that they are prepared to make any adjustments throughout the year so that they're not waiting for potentially a big bill at the end of the year?
Yeah, certainly. It's certainly a big administrative burden for employers with having to perform those reconciliations at the end of the year. Ideally, there's no easy answer, unfortunately. You do have an obligation to ensure that even if you have employees on an annualised salary, that they are being paid at least what they'd be paid if they were paid strictly in accordance with the award. Best practice is generally to perform, I guess, semi-regular audits throughout the year. Generally, we see our clients doing that when there is a pay increase, so when the annual wage increases come into effect, just to undertake, even if it's, you know, doing an audit over a month or a few weeks of their pay, just to make sure if those few weeks are representative of what they generally work, just to keep on track and identify any issues really early before you have to go down the path of doing the full reconciliation at the end of the year. But unfortunately, if people are on an annualised salary, there's no way of avoiding those award obligations to undertake the reconciliation.
Absolutely. Yeah. And another relevant one similar to that, in terms of consultation. So we often hear about consultation. So for example, the restaurant industry award changes that we've discussed is one that requires consultation. We hear about mandatory vaccinations as well, and consultation with staff, and we'll get to that as well in a bit. What do you think it looks like for employers to consult with employees? And are there any legal litmus tests that once you do this, that satisfies consultation?
Unfortunately, no, and there are often disputes about the extent of consultation that's been undertaken. One thing to be mindful of is that although awards and enterprise agreements impose obligations to consult in many respects, and as you noted, implementing the new changes to the classifications and the salaries that have been introduced recently, they do impose an obligation to consult. It doesn't mean you have to agree with the employees. So if you're introducing a new policy, including for mandatory vaccinations, if you put in place that policy, consultation means meeting with employees, listening to what and their representatives, if they've got a union representative, listening to what they have to say. Generally, you have to provide information to them in writing about the impact of the change you're proposing, and taking into account the responses that are made. So it doesn't mean just sitting there giving people an opportunity to talk and completely ignoring what they say. You do have to consider those responses and ideally provide a response to show that you've considered what's been put forward to you in the consultation, but it doesn't mean that ultimately you have to reach agreement with the employees and their representatives. It can be that you undertake the consultation process, and as an employer you decide, I've listened to what my employees have to say, I've taken it into account, but really we need to put this in place regardless of that there is some dissent. there is the potential for unions and employee representatives to commence a dispute in the Fair Work Commission if they assert that the consultation process hasn't been appropriate. And in that case, usually the first step is a conciliation with the assistance of a member of the commission. But again, it's trying to get everyone on the same page, but not necessarily, sometimes it's just impossible to reach an agreement.
Yeah, absolutely. That's very helpful. We've got a question in the chat from Emma talking about if, let's say, a cafe has 20 employees, 9 of which are juniors, let's say under 16, who work 1 shift a week, for example, school students, are they classified as a small business in relation to casual conversion?
So the definition of a small business is an employer with less than 15 employees. In calculating how many employees you have, it will include all permanent part-time employees and regular and systematic casuals. So if it's the case that you have junior employees and they work 1 shift a week every week and they'd have a reasonable expectation that that would be their shift on an ongoing basis, then yes, they would be counted within those 15 employees. If they're entirely irregular, they pick up a shift here or there where school permits, then you may be able to say that they're not counted within the 15, but it really does come down to the facts of how those employees are engaged. You'd need to be pretty careful if you've got 20 employees and 9 of them are juniors. You'd be getting close. I mean, there's probably going to be 4 of them who could say, or 6 of them that could say that they are working pretty regularly to be counted as within that small business, within the number of employees to take you over the definition of being a small business employer.
Yeah. It's one to certainly consider in terms of regular and systematic casuals. And then, we'll cover the one, which of course a lot of our members are wondering at the moment in terms of what could be the $1 million question. So they want to make vaccinations mandatory for their staff, their employees. Can they do it or not?
Yeah, definitely the $1 million question. So at the moment, there's no easy answer. Whether you can mandate vaccinations for your employees will come down to whether the direction to be vaccinated is lawful and reasonable. For those employers, and you've seen, I'm sure in the media, the warehousing, the SPC, Qantas and Virgin are now mandating vaccinations for their employees. It's difficult to know how that will play out because where you'll see the disputes is either when you have unions disputing it initially, or if somebody refuses to get vaccinated and then the employer has to take disciplinary action. But in determining whether it's lawful or reasonable to mandate vaccinations, it really needs to be assessed on a case-by-case basis. So it will depend on precisely what that employee is doing, what the risks to them are of COVID, and what the risks potentially to your customers are if they're not vaccinated. So it will take into account if they're working front of house. If you had a business in Sydney or Melbourne at the moment, you'd probably have a better chance of saying there's a high risk for your employees of being exposed to COVID versus if you're in Adelaide or South Australia. No easy answer, unfortunately. It will need and again, it will depend really on whether there's any government mandates as to vaccination. So if the government does make any health directives that say if you're working in a restaurant, front of house, you must be vaccinated, then an employer is going to be in a much better position to mandate vaccinations within their workplace. If it's simply a preference by the employer would need to show that it is a reasonable direction in terms of protecting the health and safety of both their workers and people in their workplace. And also if in the event that somebody doesn't want to get vaccinated, you do need to consider their reasons why. So if it's simply a preference not to be, and then that's easier to deal with potentially than if the person can't be vaccinated because of a genuine medical reason.
Thank you. We just got a follow-up question from Emma, who previously asked about the juniors who are part-time working 1 shift a week. Her follow-up question is, does that, as a result of that, does that mean she needs to offer the junior part-timers with permanent shifts?
If you're not a small business employer, you do need to comply with the casual conversion provisions in the award. But if you've got a genuine operational reason why it's not reasonable to convert those employees to part-time or permanent employees, then you don't have to convert them to casual, but you do have to give them reasons for the refusal to convert to to convert to permanent employment. So operational reasons will depend. It could be if you've had a massive downturn in business, or you're expecting a downturn in business, that it's not reasonable to increase your permanent workforce. Financial reasons, but it's going to depend on the circumstances of your business.
Certainly, yes, Emma, it's certainly something for you to think about. You just need to have the conversation with them, or at least be able to explain why that not be a reasonable business expectation. If you want to more specifically follow up on your situation, by all means get in touch with the IR hotline from Restaurant and Catering, which I will be helping with. And if you need, again, further specific legal assistance, then consider following up with Sarah from Wallmans Lawyers as well about that. And that was it from what I can see with the questions. And so, Alex, thank you. We will give it back to you.
And to see if Greg, if you wanted to add anything. Oh, we've just got you on mute, Greg, sorry.
Hello there.
There we go. Thank you.
It's my pleasure to thank you all, those of you who presented and those of you who attended. This is, I know you all know, an incredibly complex, detailed, and at times demanding knowledge. I just want to say again to Lungaka, to Brendon, to Sarah, thanks for the clarity you brought to something that often lacks clarity. It's really encouraging. If I may say to those of you who are with us as participants, may I encourage you please to absorb all that you can from this session. Alex has done a fantastic job. Alex, thank you for putting information together and giving us access to it. May I say too, that could you please absorb that and then sync it with your culture and your vision for your business and your belief, and then we can be good. And you are already. There are so many things going on. I would like to say how proud I am of everyone in hospitality. It's not easy, but gosh, it's fun, isn't it? And finally, I wish for everyone a really, really, really good night's sleep. Please snore your little hearts out, knowing that Restaurant and Catering, led by Wes and Belinda in Sydney, by people here, we kind of got your back. Sleep well. Thanks for being here today. And Alex, again, thank you very much.
Thanks so much, Greg. I think we'll leave it there. That's beautiful. Thank you so much. Thank you, Lungaka. Thank you, Sarah. Thank you, Brendon. And thank you, everyone, for joining us today. If you have any questions or if you needed to get in touch with us, I've just put the Restaurant and Catering hotline number there. If you are a member, have your member number ready, or you can also use your member portal to raise a ticket for one of our team to contact you at a time that's convenient. So that's your other option that you have there as a member of the association. And thank you so much and have a good week.
Thank you.
Thank you. Bye-bye.